public safety and all. Thank you. And appearing for the applicant? Yes, Your Honor. My name is Watmo, first initial R. My last name is spelled Watmouth, and my preferred pronouns are her and she. I'm an articled student appearing for the defendants, Her Majesty the Queen in right of the province of British Columbia, and the Attorney General. And I'm appearing with counsel of record, Mr. Van Camp, who is also present. Right, but you'll be speaking to the matter, Ms. Watmo? That is correct, yes. All right, and then are there any other parties? It's difficult in this scenario to identify who should be introduced next, but is there anyone appearing for the plaintiffs?
Is that myself, Victoria Nevens? Oh, no, sorry.
You are one of the plaintiffs, yes. Nevens, thank you. It's Nevens?
Correct.
Great. And, Your Honor, my name is Mac, spelled M-A-C-K, first initial C. I'm counsel for CIBC, as well as for Fulton & Company, LLP, and the personal defendants, Daniel Carroll, Harold Hicks, and Graham Mack. And my preferred pronouns are she and her, and I can be addressed as Ms. Mack or counsel. Thank you. Your Honor, I'm not intending to make submissions today, although if there's any questions as it relates to the parties that I represent, I'm happy to answer those. Thank you. And any other counsel appearing or party appearing today? I'm just a support person for Ms. Nevins, Tracy Baxter. All right, well, Ms. Baxter, you're of course welcome to be in our virtual courtroom, but I expect Ms. Nevins will be making submissions on her own behalf. So, Ms. Watmo, over to you. Yes, thank you, Your Honor. You should have a copy of the application book before you that contains 29 tabs. I do. The parties were before the Honorable Justice Punnett on January 21st, 2021, which was 3 weeks ago today. At that time, Ms. Nevins brought an adjournment application that Mr. Van Camp was advised of only the afternoon prior. We contested the adjournment, and Justice Punnett very reluctantly granted it on the basis that Ms. Nevins had not prepared any submissions. His order is captured at tab 29 at the back of the book before you. Mr. Van Camp sent this order to Ms. Nevins by email on January 26th after it was entered. And at paragraph 4 of Justice Punnett's order, you can see that Ms. Nevins' email address is her address for service, and she is here today. Your Honor, on January 21st, we addressed the issue of service before the Honorable Justice Punnett. He found that Ms. Nevins became aware of this application by January 8th of 2021. Would Your Honor like me to address the matter of service? Well, because Ms. Nevins is appearing, I don't believe that's necessary, so carry on. This is the Attorney General's application to strike the entire claim under Rule 9-5 of the Supreme Court Civil Rules. As you can see at tab 1, that's our notice of application, we seek 4 orders, and that's on page 2. And we seek a slightly revised 3rd order, that the order be granted without the plaintiff's signature and approval as to form. And this additional language is incorporated within the draft order that is located in the back sleeve of the book before you. I do note that the first page of that order will need to be corrected to accommodate the fact that Ms. Nevins is in fact appearing on the application today. All of the defendants who filed a response to civil claim have either in their application responses or via email indicated they consent to the relief that the Attorney General is seeking. And as Chelsea Mack is on the line, representing Fulton and Company and the individual defendants, Daniel Carroll, Graham Mack, Harold Hicks, and also CIBC, I'm sure she can indicate that the defendants consent to the relief sought today.
Ms. Mack, yes, I understand that's your position.
That is our position, Your Honor. The clerk has advised us this morning that Ms. Nevins entered a response to our application on February 9th, which was 2 days ago. We have not been served. Nevertheless, we have been instructed to proceed with this application to strike. And I can take Your Honor through the application responses and email if you would like to establish that the other defendants do not oppose the relief we are seeking today.
No, I don't need you to do that. I had an opportunity to review those, and I know that Ms. Nevins is the only opposition here today.
Great. Thank you. So I will now turn back to tab 1 to discuss the contents of the application. I note that the Honorable Justice Punnett, in his oral reasons given on January 21st, indicated that he had read the notice of civil claim and found that it violated, and I'm quoting here from his oral reasons, well, every rule relating to pleadings, and I submit that he is correct. As you will see, the notice of civil claim, which is at tab 6, is what I submit is prolix, incomprehensible, and impossible for the defendants, including the defendant Attorney General, to understand, to seek advice, and respond with adequate knowledge of the case that they need to meet. The claim contains Bible verses, BibleHut.net URLs, and inappropriate language throughout. And I would like to take Your Honor to page 15 of the Notice of Civil Claim, which is again at tab 6.
Yes, and there?
5 lines up from Part 2, Relief Sought, Ms. Nevins refers to herself as, and I quote, a qualified Levite priest, in brackets, teacher. Further along, she claims to be, and I quote, an expert witness who will be deferred to in all decisions and executions of fines and punishment handed out to wrongdoers responsible for their violations of the Crimes Against Humanity and War Crimes Act, racism, and indictable crimes which destroyed, and she says, my family. Now I will return back to our application, which is again at tab 1. And I'm going to paragraph 3. Here, Ms. Nevins makes numerous claims in her Notice of Civil Claim against various parties, and I've set out one example here, where she has claimed that 21 different parties have persecuted and or tortured her and her family. And those parties, as you can see at paragraph 3, are diverse and wide-ranging. Now, at paragraph 4 of the application, based on the Attorney General's close reading of the plaintiff's Notice of Civil Claim, particularly needing to read between the lines of various allegations, it appears that Ms. Nevins' underlying concern involves her allegation that in March 2009, which was almost 12 years ago now, her biological son, who she also refers to as her real property, and biological asset, was violently and without cause apprehended apprehended by the Ministry of Children and Family Development and SATANIC Police Department. According to Ms. Nevins, he was subsequently persecuted, abused, and tortured. Ms. Nevins implied in her pleading that her son was sold by the province of British Columbia to Jane and John Doe as part of a human trafficking scheme. Set out at paragraph 5 of our application, in reading the whole of Ms. Nevins' notice of civil claim, many of Ms. Nevins' claims appear to revolve around the belief that it is the job of various defendants to intervene and protect her and her son from perceived harm. For instance, she alleges that Her Majesty the Queen failed to protect her son from abuse after he was unlawfully kidnapped by witches. And that is at paragraph 60 sub J of her notice of civil claim. She alleges Her Majesty is required to serve and defend her and her son from their assailants and oppressors. And that's at paragraph 49. She also claims the Law Society had a responsibility to protect her and her son and did nothing to intervene. And that's at paragraphs 3 and 38 of her notice of civil claim. Ms. Nevins also alleges that members of the Law Society, Provincial Court, Crown, Police, and RCMP have a duty to protect her by laying private information packages against various persons and have presumably failed to do so. And that's at paragraph 37. I'm now going to turn to paragraph 60 of the notice of civil claim. Again, that's at tab 6. And that's pages 13 and 14 of the claim.
Ms. Wallow, just carry on. I'll let you know if I'm falling behind, but you don't need to wait for me to acknowledge. Thank you.
Okay, thank you. Ms. Nevins makes very general arguments surrounding the wrongdoings of Her Majesty the Queen. And I would like to bring your Honor's attention to sub B, which is on page 14, where Ms. Nevins alleges Her Majesty has failed to be knowledgeable, understand, and practice common law. Sub H, where Ms. Nevins alleges Her Majesty has failed to run our courts fairly, to acquit the innocent and condemn the guilty. And sub M, that Her Majesty has failed to understand and admit that government is created by and run for children of the devil, poisonous to the righteous, and cause of global warming. In addition to what I submit is this inappropriate language, Ms. Nevins uses inappropriate language in other instances in her pleadings when referring to various parties. For instance, as set out in paragraph 7 of our application, Ms. Nevins refers to the Ministry of Attorney General as you psycho liars. She inappropriately refers to the Ministry of Children and Family Development as the Ministry of Children and Family Destruction. Ms. Nevins regards various government departments as the usual never-ending black hole of circus of government uselessness. Although communicated partly in hyperlinks, Ms. Nevins regards the Law Society and Chief Judge as her enemies who are incapable of telling, knowing, or understanding the truth or justice. In addition to using inappropriate language to describe various parties, Ms. Nevins uses inappropriate language when referring to the court system. And this is shown at page 14 of her notice of civil claim under the heading jurisdiction. Here she indicates that there is not a legitimate, healthy, sane common law court in Canada. At paragraphs 1 and 2 on page 3 of her notice of civil claim, Ms. Nevins makes further allegations without particularizing them, including allegations of planned and deliberate attempted murder and the commission of crimes against humanity, war crimes, and advocating genocide. At page 15 of the Notice of Civil Claim, Ms. Nevins appears to make a jurisdictional argument. She claims only a Levite priest in the community is to examine the evidence and make a decision related to her Notice of Civil Claim. Under Part 2, Relief Sought, which is at pages 15 through 17 of the claim, Ms. Nevins seeks relief from numerous parties. She seeks damages in the amount of $37 million in general, special, and punitive damages and prejudgment interest. She seeks several orders asking for certain persons to be arrested, charged, tried, convicted, and sentenced to imprisonment for life. In the legal basis section of the claim, Ms. Nevins relies on several sources, including the Bible and specific Bible verses, the truth, excerpts from websites and correspondence, including ClickLaw and BibleHut.net, various statutes, regulations, and international conventions related to her claim that she is the victim of crimes against humanity, war crimes, and racial discrimination, and excerpts from the Magna Carta. Just prior to paragraph 11A, in the legal basis section of the Notice of Civil Claim, Ms. Nevins claims that she will not consent to be responsible for legal costs, which she regards as a form of witchcraft. Going back to paragraph 14 of our application, as indicated on November 13th, Counsel for the Attorney General sent to the plaintiffs a covering letter and notice of discontinuance, and as of today, we have not received a response to that notice of discontinuance. However, Ms. Nevins has indicated today that she has filed a response 2 days ago. I will now turn to the legal basis portion of the application. As there are a number of authorities referenced, I will be relying on the pleadings and the quotations contained within the pleadings. However, I will reference the tab numbers as I go in case Your Honor wishes to turn to the excerpt from the case or rules referred to. The form of pleadings and what they must contain are governed by the Supreme Court civil rules. In addition to Rule 9-5, which is of importance in this case, are also Rules 3-1 and 3-7. And these rules are set out at tab 28 of our book and paragraphs 2 and 3 of the legal basis section of the application. In accordance with these rules, a notice of civil claims must set out a concise statement of the material facts giving rise to the claim, set out a concise summary of the legal basis for the relief sought, not contain evidence, and not contain conclusions of law unless the material facts supporting them are pled. In my submission, the plaintiffs have failed to set out a concise summary of the material facts. The statement of facts portion of the plaintiff's claim is lengthy at 15 pages long and contains Bible verses and BibleHut.net URLs interspersed throughout the claim. The plaintiffs have also failed to set out a concise summary of the legal basis. The legal basis portion of the plaintiff's claim is lengthy, repetitive, incomprehensible, and contains Bible verses and BibleHut.net URLs throughout the claim. Portions of the legal basis section are incapable of supporting a cause of action, including, as discussed before, the Bible and specific Bible verses, Ms. Nevins and her experience, the truth, excerpts from websites and correspondence, and again, excerpts from the Magna Carta. The plaintiffs have also included evidence in the notice of civil claim. Ms. Nevins sets out hearsay evidence where she quotes what various persons have said to her. For instance, paragraph 8 of part 1 of her notice of civil claim references what Victoria Police Department officers said to Ms. Nevins. Paragraph 6 of part 3 of the notice of civil claim references what a complaints review officer at the Office of the Federal Ombudsman some overlap with the points made in relation to Rules 3-1 and 3-7 and the submissions I will make under Rule 9-5. Rule 9-5 sub 1 contains the authority for the court to strike pleadings. It allows the court to strike a pleading in whole or in part where one of the following thresholds are met with respect to the notice of civil claim. It discloses no reasonable claim. It is unnecessary, scandalous, frivolous, or vexatious. It may prejudice, embarrass, or delay the fair trial or hearing of the proceeding, or it is otherwise an abuse of the process of the court. The Attorney General's position is that the following proposition applies to the facts of this case. And I'm at paragraph 8 of the legal basis portion of the application, which is on page 9 there. And that's a quotation from paragraph 53 of the Simon versus Canada Attorney General decision. An excerpt of this case can be found at tab 22. And here, Justice Ball writes, the various provisions of Rule 9-5 sub 1 may apply together in the case of pleadings so overwhelmed with difficulty that it is simply not possible to fully identify all of the specific inadequacies that exist or to characterize those difficulties into the specific subparagraphs of Rule 9-5 sub 1. It is the submission of the Attorney General that the pleadings are so overwhelmed with difficulty here that it is not possible to fully identify all of the specific inadequacies that exist. Nor is it possible to categorize all of the difficulties into the 4 subparagraphs of Rule 9-5 sub 1. I submit that on the authority in Simon, that Your Honor may strike the pleading without attempting to divide the inadequacies that exist into the separate subparagraphs of Rule 9-5. However, the Attorney General has provided examples from the pleading that engage each of the 4 subparagraphs in the event Your Honor wishes to look at each sub-rule. It is our submission that the notice of civil claim can be struck under all 4 sub-rules, although Your Honor only needs to be satisfied that one sub-rule applies. Now, I'm turning the page to page 10 of the notice of application. Turning first to Rule 9-5 sub 1A, Justice Fisher in Willow v. Chong, an excerpt of which is at tab 26, summarized the principles to apply in considering whether the court ought to strike a pleading under Rule 9-5 sub 1A. And paragraphs 18 and 19 are set out at paragraph 12 of our application. And they read, the test for striking a claim as disclosing no reasonable claim under Rule 9-5 sub 1A is whether it is plain and obvious, assuming the facts pleaded are true, that the claim discloses no reasonable cause of action, has no reasonable prospect of success, or if the action is certain to fail. If there is a chance that the plaintiffs might succeed, then they should not be driven from the judgment seat. And at paragraph 19, the rule that material facts in a notice of civil claim must be taken as true does not mean that allegations based on assumption and speculation must be taken as true. And this was discussed in the Operation Dismantle decision, where Justice Dixon stated that no violence is done to the rule where allegations incapable of proof are not taken as proven. In the Young decision, set out there at 2007 VCCA 16, the court stated that great caution must be taken in relying on Operation Dismantle as a general authority that allegations and pleadings should be weighed to as their truth. But it is not fundamentally wrong to look behind allegations in some cases, and it may be appropriate to subject the allegations and the pleadings to a skeptical analysis. It was considered appropriate in Young, where the plaintiff made sweeping allegations of things like intolerance, deceit, harassment, intimidation, and falsifying documents against the defendants, which the court concluded could only be viewed as speculation. A material fact is defined as a fact order to formulate a complete cause of action. If a material fact is omitted, a cause of action is not effectively pled. And that authority comes from paragraph 25 of the Hone versus Ho decision, written by Justice Zhou, and an excerpt of that is at tab 21. Okay. Going back to the test in Willow versus Chong, in my submission, it is plain and obvious that the claim discloses no reasonable causes of action, has no reasonable prospect of success, and is bound to fail. Although I note that Your Honor only needs to find one of these to dismiss the claim under Rule 9-5 sub 1A. At paragraph 14 of our application, I have listed what the plaintiffs regard as torts or actions in their notice of civil claim that are not recognized in Canadian law as freestanding or inappropriate torts. These claims clearly contain no reasonable cause of action. And there are 8 remaining torts that were cited by the plaintiffs, and these are, at paragraph 15, fraud, extortion, common nuisance, defamatory libel, conspiracy, assault and battery, forcible confinement, and criminal negligence. I will first address how the plaintiffs have failed to plead the material facts supporting their conclusion with respect to the first 4 torts. I will then set out the law relating to the 4 latter torts and collectively explain why these claims are bound to fail. The first tort is fraud. In setting out the law, I am relying on an excerpt from the Bruno Appliance and Furniture versus Heriniak decision, and an excerpt of this decision is at tab 13. Justice Carrick-Castanis, writing for a unanimous court at paragraph 21, outlines the 4 elements of the civil tort of fraud, and this is at paragraph 17 also of our application. And the 4 elements are a false representation made by the defendant, some level of knowledge of the falsehood of the representation on part of the defendant, the false representation caused the plaintiff to act, and the plaintiff's actions resulted in a loss. In my submission, the plaintiffs have pled fraud, which is a conclusion of law, without material facts supporting their conclusion, also in contravention of Rule 3-7. This cause of action is not effectively pled. I submit that the plaintiffs have failed to identify anything that can be construed as a false representation made by any of the defendants. The plaintiffs have failed to address how the false representation caused them to act and how the plaintiff's actions resulted in a loss. In my submission, it is plain and obvious the plaintiff's action of fraud has no reasonable prospect of success and is bound to fail. Moving on to the second tort of extortion, the authorities refer to the tort of extortion as another name for the tort of intimidation. The 2 terms appear to be interchangeable. This is demonstrated by the Metropolitan Conference Center, Inc. versus Hunter decision of Justice Miller. An excerpt of this is at tab 16. The elements of the tort of intimidation or extortion were concisely set out by Justice Sigurdsson in the Sportstown BC Holdings Limited versus British Columbia Soccer Association decision. An excerpt of this is at tab 23 of the materials. The relevant paragraphs are paragraphs 74 and 75, and I will read an excerpt from paragraph 75. The essential ingredients of the tort of intimidation are the same throughout. There must be a coercive threat to use unlawful means so as to compel a person into doing something that he is unwilling to do or not doing something that he wishes to do, and the party so threatened must comply with the demand rather than risk the threat being carried into execution. The plaintiffs have pled extortion, again, a conclusion of law without material facts supporting that conclusion, in contravention of Rule 3-7. The plaintiffs have failed to identify a coercive threat directed by any of the defendants to use unlawful means to compel any of the plaintiffs into doing anything they are unwilling to do. I submit it is plain and obvious the plaintiff's action of extortion has no reasonable prospect of success and is bound to fail. Your Honor, before moving on to the next tort of common nuisance, I note the time. Would you like to take a break now, or would you like me to continue?
I'll ask that you continue, Ms. Watman. We'll go until 11:15.
Okay, thank you. Moving on to the third tort, which is common nuisance. Although the plaintiffs have pled common nuisance, I submit the correct tort this court should consider is the tort of nuisance. In the Lawrence Cement Inc. versus Beret decision, Justices LaBelle and Deschamps, writing for a unanimous court, outlined the elements of the tort of nuisance. An excerpt from this authority is at tab 24 of our application book. I have set out paragraph 77 in the application, and that's at paragraph 23. And I would like to draw your attention to the sentence at the third line down. And that reads, nuisance is defined as unreasonable interference with the use of land. The plaintiffs have pled common nuisance or nuisance, which is a conclusion of law without the material facts supporting that conclusion in contravention of Rule 3-7. The plaintiffs fail to identify anything that could be characterized as an interference with the use of land. It is plain and obvious that the plaintiff's claim of nuisance has no reasonable prospect of success and is bound to fail. Moving on to the fourth tort, which is defamatory libel. Where plaintiffs have pled defamatory libel, this court has addressed the claim as a claim of libel. And this is shown in the Wood versus Bryant decision of Justice Affleck, and an excerpt of that is set out in our authorities at tab 27. The essential elements of libel are untrue words that are defamatory of the plaintiff that the defendant published. And this definition comes from paragraph 32 of the Kelly Pamphlet Construction Limited versus AXA Pacific Insurance Co. decision, which is written by Justice Klebuck. An excerpt of this is at tab 15 and also referred to as paragraph 26 of our application. The plaintiffs have pled defamatory libel, again, a conclusion of law without material facts supporting that conclusion in contravention of Rule 3-7 sub 9. The plaintiffs have failed to identify anything that could be characterized as untrue words that are defamatory of the plaintiffs that were published by the defendant. It is plain and obvious that the plaintiff's claim of defamatory libel has no prospect of success and is bound to fail. Now, moving on to the latter four torts, which are set out at pages 15 and 16. I will set out the law for each of these four torts and then collectively address these claims because I have the same submission on all four. First, I will move on to the law regarding the tort of conspiracy. In Willow versus Chong, again, an excerpt of which is at tab 26, Justice Fisher outlined the elements of the tort of conspiracy, which is at paragraph 67, also at paragraph 28 of our application. These elements are, there's three essential elements that all must be pleaded, and they are an agreement including a joint plan or common intention by the defendant to do the act which is the object of the conspiracy. Second, an overt act consequent on the agreement. And third, damage. And then there's an excerpt from the court in Kahn versus American Credit Indemnity Co. With respect to the defendants needing to intend to be a party to that conspiracy. And that's set out at paragraph 28. Now I will address the law regarding the torts of assault and battery. And again, that's at paragraph 29 of our application there. The elements of the torts of assault and battery are set out in the Provencher versus St. Paul's Hospital decision, an excerpt of which is at tab 19. At paragraph 41, set out in our application there, Justice Daugherty states, the authorities establish that the tort of assault is the intentional creation of the apprehension of an imminent threat of harm. It is rooted in a wrongful act which disturbs the victim's sense of security. The tort of battery is the intentional infliction of harmful or offensive authority of another. Moving on to forcible confinement, which is at paragraph 30 of our application. The tort of forcible confinement was referred to in passing by Justices Brown and Rowe, dissenting in part, in the recent decision of the Supreme Court of Canada of Nevsun Resources Limited versus Aria, and an excerpt of this decision is at tab 18. However, throughout the authorities that we have reviewed, the tort is generally referred to as the tort of unlawful confinement or false imprisonment rather than the tort of forcible confinement. And Justice Abella, writing for the majority in that decision, and Justice Newberry, writing for a unanimous court in the Arshenkov versus British Columbia decision, referred to at paragraph 30, also an excerpt of which is at tab 12, referred to the tort of unlawful confinement as another name for the tort of false imprisonment. Justice Garceau, writing for a unanimous court of appeal in the Hyung versus Silvercourt Metals Inc. decision, an excerpt of which is at tab 16, confirmed that the elements of the tort of false imprisonment are as follows. The plaintiff has been totally deprived of his liberty against his will, and the imprisonment was caused by the defendant. And those are set out also at paragraph 31 of our application. Moving on to the final tort, the plaintiffs allege the defendants were criminally negligent. The tort that this court should consider is the tort of negligence. A successful action in negligence requires the plaintiff to establish that a defendant or defendants owed them a duty of care, breached the requisite standard of care, the plaintiff or plaintiff sustained damage, and the damages were caused by the defendant's breach or breaches. And this principle comes from the often cited Mustafa versus Culligan of Canada limited case, written by former Chief Justice McLaughlin for a unanimous court, and an excerpt of this decision is at tab 17 of our authorities. The factual bases of the plaintiff's claims relating to the four latter torts of conspiracy, assault and battery, forcible confinement, and criminal negligence appear to all emerge from the same factual scenario. The plaintiff, Ms. Nevins, appears to believe that her son, Arthur Nevins, was violently removed from her care and placed into foster care without cause, kidnapped by witches, and sold to buyers in a human trafficking scheme. Relying on the authority in paragraph 19 of the Willow versus Chong decision, an excerpt of this is at, again, tab 26. It is appropriate in these circumstances where the plaintiffs have made sweeping allegations to subject these allegations to a skeptical analysis. I submit that this court should regard the plaintiff's claims as based on mere speculation with no prospect of success and are bound to fail. In conclusion on this subrule, I submit that this claim should be struck in its entirety under Rule 9-5, sub 1A. It is plain and obvious that the claim discloses no reasonable cause of action, has no reasonable prospect of success, and the action is bound to fail. Now I'm next going to move on to Rules 9-5, sub 1B and 9-5, 1C, which I will address together. And again, there's some overlap with my submissions on Rules 3-1 and 3-7. In the Public Guardian and Trustee of British Columbia versus Johnston decision, an excerpt of this decision is at tab 25. At paragraphs 51 to 53, which are set out at paragraph 37 of our application, Justice Ballant summarized the principles to apply in considering whether the court ought to strike a pleading under these subrules, and again, subrule B and C. The principles that I take away from these paragraphs are as follows. Where pleadings are so confusing that it is difficult to understand what is being pled, they are irrelevant and embarrassing. Where a pleading is so irrelevant, it involves parties and useless expense, that pleading is embarrassing and scandalous. Where a pleading does not go to establishing the plaintiff's cause of action or advance any claim known in law, it is unnecessary or vexatious. where a pleading does not state the real issues in intelligible form, is overly prolix, includes irrelevant facts, and is calculated to confuse the opposing party and make it difficult and perhaps impossible to answer, or contains argument or evidence that pleading is embarrassing or scandalous. In my submission, all of these principles apply to the notice of civil claim. The notice of civil claim is embarrassing, scandalous, unnecessary, and vexatious under Rules 9-5 sub 1b and 9-5 sub 1c. And this is for a number of reasons, including the following. The notice of civil claim is so confusing, it is difficult to understand what is being pled. The notice of civil claim does not state the real issues in intelligible form.
Wow.
It is instead a mixture of bald allegations, Bible verses, hyperlinks, URLs, and inappropriate language towards the parties and the court. The notice of civil claim is overly prolix. It contains 24 pages of disorganized and repetitive narrative. The notice of civil claim contains irrelevant facts, including these Bible verses, hyperlinks, and URLs. It contains a series of unconnected, speculative allegations against various parties. The notice of civil claim also contains argument and evidence throughout. It does not go to establishing the plaintiff's cause of action and advances many claims not known in law, as addressed. I believe there are about 21 listed in our application. Although the Attorney General has tried its best, the notice of civil claim makes it difficult, if not impossible, for the Attorney General to understand the case that must be met and to respond to it. Lastly, the notice of civil claim has and will continue to involve parties in useless expense. I submit that this notice of civil claim should be struck in its entirety under Rules 9-5 sub 1b and 9-5 sub 1c. Lastly, the Attorney General relies on Rule 9-5 sub 1d, which permits Your Honor to strike the pleading due to it being an abuse of the court process. As set out by Justice Smith for a unanimous court in Quinn versus British Columbia, and an excerpt of this is at tab 20, and also referred to as paragraph 41 of our application. Abuse of process is a flexible doctrine used to prevent claims that violate principles of judicial economy, consistency, finality, and the integrity of the administration of justice. The plaintiff's claim violates the principles of judicial economy and undermines the integrity of the administration of justice. Taking up court time to allow what I would describe as nonsensical arguments to proceed is directly in violation of the principle of judicial economy and undermines the integrity of the administration of justice. And I submit that this claim should be struck under Rule 9-5 sub 1d as an abuse of process. Am I able, Your Honor, to have a moment to confer with Mr. Van Camp? Oh. Sorry, I can't hear you.
I'm muted there. We'll take the break now. And I did, so you're aware, an application record from Snowden's, it appears, and it includes an index of number 1, response to notice of application, number 2, affidavit number 2, and I'm getting an echo, Madam Clerk, up here. I don't know what that is all about, but in any event, affidavit number 2 of Victoria Nevins, and then exhibits A, the situation, B, notice and demand, return my real biological property forthwith, C, Johnny Van Camp exposed, E, February 11th, 2021, directions to the court. So I just wanted to make you aware of what I have, and so that will, I suppose, be subject matter of further submissions, but we'll take a 10-minute break now. Thank you.
Thank you. We're in court.